Mr. Miller, you want to come up to the podium? So this is in the matter of Pamela K. Parker versus Charles Paul Miller, file number 2002-25512DS. Mr. Miller is present in person. So this is the date and time set for a show cause. It states here that you have an arrearage of $10,329.55. Do you understand that?
Yes, ma'am.
Okay, and it's arrearages only. There's not a current charge. And we haven't received a payment since 2021. So Mr. Miller, are you currently employed?
No, I filed for Social Security and it's in the, they say it was approved, but I'm waiting for all paperwork and stuff to come through.
So you applied for disability or SSI?
So
Disability. And you went to a hearing?
Yeah.
And it got approved?
They say that I have nothing in writing yet, so.
Okay, who's they and when did they say that?
I had a hearing at the administrator, here at the agent office.
Okay.
And there's like a Zoom hearing, and they said that everything would look favorable. That's all it said.
Okay, did you have an attorney?
No.
No? Okay, and did they say when you would hear something?
Said 30, up to 30 days. So there's probably be next week or week after.
Okay.
2 weeks ago when I was there.
Okay. All right. And, okay. So, Mr. Miller, your address shows suppressed on my file, so I'm not going to get it on the record for whatever reason. So I'm going to need you to go down to front of the court. Okay. Jeff Anderson is your caseworker. I need you to give him a valid address.
All right.
Okay. And then I need you to, you said about 30 days, so you should hear in a week or two.
Yeah, it was about 2 weeks ago.
It was about 2 weeks ago. Okay, so, I'm gonna set this over to September 23rd. Now, Mr. Miller, you may get a lump sum, but you're gonna need to pay this off.
Yeah.
With that lump sum. Do you understand that?
Yeah.
And then once you get it, we're still gonna need payments till it's paid off.
Yeah.
So even though you get disability, you still have to pay this off.
Yeah.
Do you understand?
Yep.
Okay, so I'm gonna set this over to September 23rd at 8 a.m. And I'm giving you the notice on the record. I'm gonna send you down to front of the court now, go down to the basement, go to the front window and check in and then give them your valid address. And we'll see you back on September 23rd. When you get a letter from the Social Security Administration, I'm gonna need you to bring that in and give that to Mr. Anderson, okay?
All right.
Okay, all right, so go on downstairs.
All right, thanks.
Thank you. All right, so what is your name?
Dave Dillard.
What is it again?
Dave E. Dillard, Lyard.
Okay,
Judge, he is
Yes.
to be in Old Savers courtroom.
okay, you're supposed to go to the next door. Other judge, what's your name?
Please, Sane.
Okay, let me find you. All right, Mr. Sane, you want to come up to the podium? Yep, just kind of push it. Yep, there you go. Okay, so this is in the matter of Amy Colleen Latham versus Clay DeCarl Sane, file number 2016-43348DS. Yep, take your hat off. Mr. Sane, we're here because you're ordered to pay $329 or $320 a month of child support. And as of today's date, you have an arrearage of $2,343. Do you understand that?
Yes.
Okay, The last payment we received was $89.95 back on January 23rd of 24. We haven't received anything since. Do you understand that?
Yes,
Okay. Do you understand that it's a crime to fail to pay child support up to the very best of your ability?
yes,
So on a first offense, you could be facing up to 45 days in jail, and a second offense up to 90.
okay,
Okay, and then if your rearage gets high enough, like about 9,000 or more, the state of Michigan can charge you with a 4-year felony. Do you understand that?
okay.
Okay, I'm always just trying to make sure you understand. All right, so Mr. Sane, are you currently employed?
Yes,
Okay, where are you working at?
Fazoli's,
Fazoli's?
yeah,
Not around here. Where are you working?
no, in Lansing.
In Lansing?
Yes.
Okay, and how long have you been working there?
Few months.
A few months. And which Fazoli's, is there more than one in Lansing?
I think so. I work at the one on South Cedar.
We used to have one here. It was really good. All right, Fazoli, Lansing. Okay, so 5705 South Cedar Street in Lansing. And looks like the phone number is 517-394-0539. Okay. All right, so Mr. Sane, a couple things. You're supposed to pay $320 a month. Is that based on a job where you made more money?
I'm pretty sure. I haven't been to one of these in years.
Okay, so if you're making less money than you did back then, you're probably entitled to an income review, which means you submit your financial paperwork and they recalculate child support. Do you understand that?
Yes,
To do that, today you would go down to the basement to the front of the court and ask for the paperwork to do that.
okay,
And then you would have to file it, okay?
yes,
And you probably can get an income waiver, I'm not sure, but they'll provide that to you as well. And in the interim, you need to pay $80 a week on this.
okay,
And you can pay that online until we start taking it out of your check,
okay,
okay? So you downstairs, I'll have paperwork that you can get the information to make the online payment.
okay,
So I need you to make payments online, and once it starts coming out of your check, then you won't have to make the payments online.
okay.
Okay, do you have any questions?
No,
All right, so I'm gonna adjourn this out to September 23rd to make sure that you're making the payments online and that we got an income withholding, okay?
okay,
If you change jobs, you need to let friend of the court know right away. So
okay,
we can do the income withholding. And remember, if it doesn't come out of your check, you need to make it online, all right?
okay,
So it works out to $80 a week, but you probably need to have an income review. So I want you to go down to front of the court. I want you to verify your address, get the paperwork for an income review, and the paperwork showing you how to pay online.
okay.
You have any questions?
No,
All right, so we'll see you back September
that's
20th,
not on the first floor,
all the way to the basement.
all in the basement.
Yeah, not floor one, the one below it. I think it says, I don't know if it says B or G for garden level, but it's below the first floor.
Okay,
And we'll see you back on September 23rd and hope everything is going well. All right?
thank you.
All right, thank you.
I just need a signature something.
What did I do? Oh. It's a bad boy, this is. All right, thank you. You can tell the jail I'm ready for him. All right, Anthony Ruger, my waiting room. Hey, Mr. Ruger, can you hear me?
I can hear you. Can you hear me?
I can.
Judge, I have him on the docket, but I don't have him on the. So it was adjourned to 8:26, maybe?
I'm sorry.
I'm not sure if that means it was adjourned out, 8:26.
Yeah, I always call those two.
I don't have him on the docket, so give me just a second.
I'm looking for him right now. Yeah, hold on, Mr. Ruger.
Okay.
All right. So we call those, I don't know who entered, I'm sorry. I do call the adjournments on the record.
Oh, okay, I was not aware. Okay.
Yeah, I call them just so people have notice.
Okay,
So tell me when you're ready.
okay, I am ready.
All right, in the matter of Megan Sue Ruger versus Anthony Lloyd Ruger, file number 23-50368 DM. So Mr. Ruger, that's been adjourned to August 26th at 8 AM. So it looks like you're doing whatever you're supposed to be doing, and we'll see you back on that day, all right?
August 26th at 8 a.m.
Yes, sir.
All right. Thank you very much.
Thank you. Have a good day.
You too.
Lewis. All right, now Mr. Lewis is next, and he's on the middle of page 1 that was adjourned to September 16.
Okay. Him I do have.
Hmm.
Him I do have on the docket.
Oh, okay. I'll let him in. Is Mr. Lewis been compliant? So are we going to some point dismiss if he continues compliancy? Anybody? Okay. Mr. Lewis, can you hear me?
I hear you.
All right, good morning. So this is in the matter of Catherine Rink versus Michael Lewis II, file number 2009-34541 DP. So Mr. Lewis, this has been adjourned to September 16th. So it looks like everything's going well. Thank you.
No problem. Have a good day.
You too. Thank you. Bye. In the matter of Amanda Martinez versus Floyd Cole, this is the date and time set for front of the court show cause on file number 2008-32533 DS. Mr. Cole was ordered to appear this morning. He has failed to do so. He's ordered to pay $160 a month in child support. As of today's date, he has an arrearage in excess of $12,907. The last time he made a payment was on a warrant, and he made a payment of $500 on April 24th. We were back here on June 24th of 24, and he was ordered to make the July and June payment and obtain employment. He has failed to do so. He's failed to appear today in person as I requested. So I'm going to issue a bench warrant for his arrest for failure to appear. And I'm going to set bond in the amount of $4,000 cash. In the matter of Vanessa Villegas versus Keegan Stewart, file number 2007-31127 DS, that matter has been dismissed. We have 2 files with Floyd Cole. We have Shauna Cobell versus Floyd Cole, file number 2008-32533 DS. On that file, Mr. Cole is ordered to pay $160 a month in child support. As of today's date, he has an arrearage of $12,907. Oh, wait, did I already call him?
Yes, Your Honor.
Okay.
Yes.
Ron Cole. Okay, so that was Amanda Martinez. Okay, so I did that one. And now this is the other Cole. So on this file, same thing. He paid on a bench warrant back in April. He appeared in June. I asked him to appear today in person with employment and payment. He hasn't done so. I'm going to issue a bench warrant for his arrest. And place bond in the amount of 4,000 cash. All right. Moving on to Blake Rinky. The matter of Kayla Taylor Forrest versus Blake Rinky, file number 2010-35508 DP. That matter has been adjourned to August 26th. You got to enter that one.
Okay,
Do you have to?
I do not have it.
Okay.
Sorry.
No, it's okay. Go ahead and enter. And then if you want to enter Mr. Hernandez too, I got the jail.
Yeah, I'll need to enter him too.
Mike.
No, there isn't. You got charged, Mr. Stevenson.
Last one.
Your elevator around 315
I'm just letting, Linda's entering some information in, so that's what I'm waiting for. Give me just a minute.
This is absolutely embarrassing.
Hey, Judge. Okay,
Absolutely
You ready?
embarrassing.
All right, this is in the matter of the people of the state of Michigan versus Pedro Hernandez, file number 2023-21526FH. Mr. Hernandez, can you hear me?
Yes, Your Honor.
All right, so Mr. Hernandez, we are here on a violation of probation, which alleges that you violated your articles of probation dated May 17 of 2024, specifically article number 1 and article number 13, and that you consumed alcohol and committed the act of OWI 3rd and leaving the scene of an accident on August 4th of 2024. Do you understand that those are the allegations against you?
I understand that.
All right, now, Mr. Hernandez, you do have a right to have an attorney represent you on this and all subsequent hearings. In light of the fact that you most likely are being arraigned this morning on new charges, would you like an attorney appointed to represent you?
Absolutely.
Okay, very good. All right, so Mr. Hernandez, we're gonna put you on hold for a moment, and then we're gonna get a court-appointed attorney for you. Ms. Adams, if we're not able to get one right away, I'll let him back in and let him know. So Mr. Hernandez, I'm gonna pop you in the waiting room real quick, okay?
Okay.
All right. Okay, so in the matter of Ashley Dalton versus Christopher Ellinger, file number 2012-37584DS. This is the date and time set for a show cause. Mr. Ellinger is ordered to pay $237 a month in child support. He has an arrearage of $13,226. The last payment we received was $250 on June 24th of 2024. We made a payment of $250 like I asked, and we adjourned it. We did an income withholding to flexible staffing. he terminated his employment on May 12th. He played pretty well from September until January. So unfortunately, he stopped paying. So I will issue a bench warrant for failure to appear. And I'm going to set bond in the amount of 3,000 cash. All right. The matter of Alexis Regalado versus Zachary Ryan Dillard, file number 2014-40671DS. That matter was dismissed. Did you have that one, Linda?
I do, Judge.
Okay.
yes.
In the matter of Selena Joe Keller versus Dino Pelham III, file number 2015-41502DS. Let's see. All right. Does anybody have a hearing here today? Okay. What's your name? Heather Weaver. Okay. All right. Mr. Pelham was ordered to appear today and he's failed to do so. Mr. Pelham is ordered to pay $251 a month in child support. As of today's date, he has an arrearage in the amount of $1,896.69. Okay, I'm going to issue a bench warrant for his arrest for failure to appear, and I'm going to set bond in the amount of 2,000 cash. In the matter of Terry Barnhart versus Jody Colruss, file number 2015, no, 2016-43454DC. That matter has been dismissed.
I do not have that on my,
Okay, go ahead and
I'm
enter.
so sorry, Judge.
It's okay, don't worry about it. Miss Adams, were you able to reach Miss Underwood?
Yes, she is currently with Judge Olsaver. I'm not sure how long she'll be over there.
Okay. Mr. Hernandez can wait.
Okay, Judge.
You ready? Okay. So that one's dismissed. I don't think I called Reyes. Somebody call that one. Got somebody in the waiting room on an iPhone. So I have somebody who's logged in on an iPhone. I'm going to send you a request to unmute if you could give me your name.
David Shords.
Could you say that again?
David Shords.
All right. Good morning, Mr. Shorts.
Morning.
All right. Let me find you. All right. Mr. Shorts, we'll be with you in a minute. I'm finishing up my front of the court docket. All right.
Yes, Your Honor.
Thank you. All right. In the matter of Nicole Reyes versus Christopher Reyes, file number 2015-41906DM. Mr. Reyes was ordered to appear. He's failed to do so. He's ordered to pay $256 a month. As of today's date, he has an arrearage in the amount of $22,122. Last payment we had was $350 on June 11 of this year. He did pay $1,200 in June. And we haven't seen anything since. So I'm going to issue a bench warrant for failure to appear and set bond in the amount of 3,000 cash. In in the matter of Haley Nicole Wells versus Kyle Anthony Sneed, file number 2019-46276 DS. This is the date and time set for show cause. Mr. Sneed was ordered to appear. He's failed to do so. He is ordered to pay $347 a month, and he has an arrearage of $7,606. We had a payment of $79.90 on June 21st of 2024. I'm going to issue a bench warrant for his arrest for failure to appear. And I'm going to set bond in the amount of $2,500 cash. We have Frank Core and Pierce on the next one.
I'm sorry, Judge, which one?
The next one were Frank Core, Snyder, and Double. I just was checking to see if you had them entered.
Let me read it.
Yeah. Okay, will you get a notice for her?
I don't have any of those on, Judge.
It's okay, go ahead.
Okay.
Ms. Adams, could you come back in?
Yes.
Because if it was hers, they don't get to do that without her permission. So. Check.
Okay, Judge, those three are entered now.
They're in now?
They're
Okay.
in.
And in the matter of Melissa Francoeur versus Terrence Pierce, file number 2019-46386 DS, that matter has been dismissed. Rachel Lynn Snyder versus, oh, I got a Brandon. Right, Brandon, if you could unmute your device, please. Are you Brandon
Yeah.
Snyder?
Hi, good morning.
Good morning. Are you Brandon Snyder?
No, Brandon Green.
What's your last name?
Green with an E on the end.
Okay, hold on. I'm going to rename you.
Okay.
Okay, all right. I'm going to pop you in the waiting room. I'll be right with you. So in the matter of Rachel Snyder versus Brandon Snyder, file number 2020-47798 DM, that matter has been adjourned to September 23rd. In the matter of Faith Star Double versus Austin Doobie, file number 22-49172 DS, that matter has been dismissed. And that concludes our final court show cause docket. Okay, so I'm gonna need that rescheduled sooner. Because it's a month out and I don't know what the objection is for. Like, I don't know what kind of court order that she's objected to. So I'm gonna give you a file number that we got a call today, Linda.
Okay,
It's not on the docket.
all right, Judge.
So it's file number. Sure. She's gonna give it to you. Ms. Beer, you wanna come up to the podium? That's fine. I just, yeah, we're gonna need a date sooner, but. All right, so Ms. Beer, we're gonna enter the information. We're gonna call your case in 1 minute, okay? So just give me 1 minute.
Do you need this back, Judge?
Nope. Okay. All right, tell me when you're ready.
I am ready.
All right, so this is in the matter of Heather Beer versus Austin Beer, file number 22-49501 DM. So Ms. Beer, today was scheduled the date and time set for your objection to the friend of court referee hearing. So my assistant and I were out of the office for about 12 days and we got a request for an adjournment by opposing counsel. And it actually got set out to September and that's not gonna work for me. I want it to be sooner because you obviously are here today and it looks like you didn't get notice that it got adjourned. Say no, okay. So originally it got set out to September 16th, but that's too far away for me because I want it to be heard sooner. So Ms. Adams, are we able to get a date sooner than that?
I'm looking, Judge.
It doesn't have to be a Monday.
Right.
And it'd be about, I don't know, a half hour.
Judge, we could do August 19th at 4:10 p.m.
Could you do that day? Okay.
Yes.
All right, so that gives us, that's 2 weeks. So we'll mail out the notice, okay? So we don't have to worry about that. So August 19th at 4:10. All right, and then do you want a notice of hearing to take with you today?
No.
Okay, and you want to just take a second? Okay, Ms. Adams, we'll mail out the notice. Could I get a notice from Ms. Beer?
Is there a reason why it was adjourned?
We don't know that. Like I said, we were gone and the attorney requested an adjournment and I'm not sure why. So they set it out to September, but that's too far away.
I filed in April.
I know, but that's too far away, so I'm gonna set it closer and then we'll mail out the notice. So just have a seat on that bench behind you and we'll get your notice of hearing, okay? And I apologize, but, all right, Mr. Hernandez, hold on, I've got counsel. All right, Ms. Underwood, we're back on the record in the matter of the people of the state of Michigan versus Pedro Hernandez. Ms. Underwood, did you receive the paperwork from Ms. Adams?
Hang on, Your Honor. Let me see if I did.
I'm not a criminal. I suffer with an alcohol problem. I'm not a criminal.
Mr. Hernandez, just be quiet, please, until you talk to your attorney. Not telling me anything I don't know.
I don't see it, Your Honor.
Miss Adams, did Miss,
I sent it at 8:18 this morning.
I'll send it to you via text. I'm sure Miss Underwood. So Miss Underwood, it's actually pretty simple. Mr. Hernandez, the allegation is a technical violation. It's alleged that he consumed alcohol and committed an act of an OWI third and leaving the scene of the accident yesterday. He was arrested. Looks like he's probably going to be arraigned today in district court. So I made sure he understood he had a right to an attorney because of those pending charges. Did you find the paperwork yet? All right, I'm going to open up that breakout room for Miss Underwood. Mr. Hernandez. Go ahead and join that breakout room. All right, Miss Stone.
Good morning, Your Honor.
We'll be with you in just a minute.
Thank you.
Mr. Green, could I ask, what case are you hearing?
Can you hear me now?
Yes, which case
Okay.
are you hearing?
The case number
Sure.
it is 1643534. Dash D as in dog, P as in Peter. It's the objection to the recommended child support order.
2016 dash, and what's the last 5 digits?
43534.
Miss Adams, I don't have that file number.
I don't either, Judge.
You did?
I do
No.
not.
I apologize.
Are you a
Judge.
name?
What was the case?
16 dash, say it again, 43, what was it, Mr. Green?
43534.
So it appears that there was an order done denying that, Judge.
Okay, so Mr. Green, we issued what we call a Conlin order, which means that the objection was reviewed and an order was issued, so you will get that in the mail.
Okay. What was the result of the
I
objection?
don't know. I don't even have your file with me, so I don't remember. Okay?
Okay.
All
Okay.
right, thank you. Have a good day.
Thank you. Bye.
Bye. I'm gonna close the breakout room and bring Mr. Hernandez back, Ms. Underwood, and then we will, all right, Mr. Hernandez. Now, Mr. Hernandez, you had requested court-appointed counsel. We appointed Ms. Underwood to represent you. Mr. Hernandez, you are here on an operating while intoxicated third offense. That offense, if you plead guilty or found guilty, can result in a term of prison up to 5 years. Do you understand that?
No,
Well, you do. When you were here before, we arraigned you and you
I
pled
do.
guilty to an OWI third. You knew the maximum penalty could be up to 5 years in prison. Is that correct?
yes, Your Honor.
And that still applies today. So the maximum penalty, if you were to plead guilty or be found guilty, could be up to 5 years in prison. Now, you asked for court-appointed counsel, and as I said, we appointed Ms. Underwood to represent you. You've had a chance to talk to her. Ms. Underwood, is he eligible for court-appointed counsel?
I would say so much.
Okay, and how would you like to proceed today, Ms. Underwood?
Your Honor, I'm a little confused. We're here on a violation of probation, correct?
Yes, ma'am.
Okay, because I don't believe he's been arraigned on the OWI yet.
He got arrested yesterday, so I'm sure it'll be today sometime.
Right, but it sounded like you were arraigning him on that.
I'm arraigning him on the FOP, yeah.
Okay.
Well, he's on probation with me for an OWI third, and now we got another charge of OWI third.
Thank you. Your Honor, we obviously will plead not guilty to the violation since there is going to be a pending case. And we would ask that this be set out to see how that proceeds. We would also like to discuss bond in this matter, Your Honor.
Miss Adams, when, probably at least a couple weeks out, or Miss Underwood, you thinking 2 weeks out?
Yes, Your Honor.
All right, Miss Adams, I don't know if August, let me see here, 14 or 21 had any available dates? At 8:30?
We have about 20 cases August 14th and a jury trial.
All right,
August-
so 20,
August 21st, we are doing arraignments only due to a jury trial, but we can fit it in there, I believe.
is there any time on August 15 or 16?
No. Hold
No?
on 1 second.
Rhonda, do you represent Stephen Wolfus set for trial next week?
Yes.
Is that going still?
Your Honor, Mr. Woltheis is was seen by the forensic center I believe Thursday or Friday, and I don't have
So
any-
trial's not, so the
I don't
trial's not
think
gonna
so.
go. Okay, so why don't we set this for 10:30? All right, so what I'm gonna do is set this over to August 14th at 10:30 in the morning. And Miss Adams, you can address bond.
Your Honor, Mr. Hernandez is working. He has a home he does not want to lose. I think the court could order any conditions the court feels comfortable with as far as alcohol monitoring, Your Honor, and monitoring through Mr. Coast to assure the court confidence in Mr. Hernandez's sobriety pending further court, Your Honor.
All right, Mr. Stevenson, would you like to weigh in on the request for a GPS and alcohol monitor or anything like that?
Sure, he's on for OWI 3rd. He's not permitted to use alcohol or to drive. He's done both this weekend. He's got new charges. I think he should remain in jail.
Okay, and a non-technical probation violation can carry a maximum of?
5 years.
It's not the 14-day.
This should be a non-technical.
Okay, so
it's a new offense, so you have 5 years.
So it's not limited.
Correct.
All right, so Ms. Underwood, I'm sorry, I'm not going to release Mr. Hernandez. He's on probation on a felony third drunk driving, and he committed another one and left the scene of an accident. Not only is he a danger to others, he seems to be a danger to himself and unable to control himself. So no, I am not going to release him. His bond is set at, I'm going to set his bond at 25,000 cash. And we can review it again on August 14th. Thank you. You're all set, Mr. Hernandez. I'll enter a plea of not guilty.
Thank you.
Thank you. Thank you. Can you
Is
take
that it,
it?
Underwood? Underwood, is that it?
Thank you.
Thank you. Mr. Hernandez, you're all set. Thank you. All right, Ms. Underwood, thank you.
Do you have anything else, Your Honor?
That was it this morning. Did you have any of the FOC cases?
Which ones do you have, Your Honor? I'm sorry.
I'm done with all of them, but I didn't know who you had this morning listed.
Well, did you have Michael Lewis or Zachary
Mr. Lewis?
Dillard?
Mr. Lewis got adjourned to September 16th. Who was the other one?
Zachary Dillard.
That got dismissed.
And John Diaz.
John Diaz?
Yeah.
He must have got dismissed. He wasn't on my docket.
Okay. Thank you, Your Honor.
All right, awesome. Thank you, Miss Underwood. All right, I'm gonna let Mr. Shorts in. Sorry, give me just a second. Hold on, Mr. Shorts. Let me get paperwork. All right, this is, oh, there's more. Is in the matter of David Shorts versus Jessica Sue Shorts, file number 2020-47465 DM. I have Jenny R. Stone, P77883, appearing on behalf of the defendant. All parties are appearing via Zoom. We are here today on plaintiff's objection to the referee's recommendation and order. Both parties petitioned for a referee hearing regarding the issues of child support and parenting time. The referee determined there was no reason to modify the parenting time schedule. The referee did determine that it was appropriate to change some parenting time conditions, adding a licensed driver whom the children are familiar with must transport the children. Parenting time exchanges will continue to take place in Albion. Neither parent will record parenting time exchanges. Neither parent will disparage the other parent or anyone in the parent's household in front of the children. Neither party will discuss enrolling the minor children in extracurriculars with the children without first discussing with the other parent. Neither parent will schedule summer activities outside of their own parenting time without the consent of the other parent. And the parent will forfeit a parenting time phone call made later than 5:15. They also entered a uniform child support order. Mr. Shorts, you objected to everything as you essentially alleged that defendant mother is alienating the minor children and you're indigent, so you can't afford support. You did provide, thank you, a very thorough brief. Some of the things I wanted to talk to you about is what is, let me look at your judgment support.
Your Honor, may I add one thing real quick?
Yeah.
So we did file an objection as well. I called and I got a court date of August 19th of 2024 at 9 a.m. We mailed it in on the 26th and I served a copy to Mr. Schwartz. In the meantime, he must have gone to the clerk's office, filed an objection, and he got this date. So it's my understanding we have two different dates for objections, but both plaintiff and the defendant have filed an objection.
Yeah, I know that. I was just going through his.
Oh, okay. All right. Just wanted to make sure
that
because
you,
we have the different
you
dates.
have an objection that she wants to be able to enroll the children in extracurriculars during the school year. That's your objection,
Yes,
right?
Yes.
Yep,
Just clarification.
Yep. I just hadn't gotten there yet.
All right. Thank you. Sorry.
That's okay. Let's see. So Mr. Shorts, I was looking back at the judgment. Let me see here. Let me find the judgment of divorce. Somewhere back here. Oh, this is a second file. So, Mr. Shorts, are you saying that there's a clause in your judgment of divorce that the parties be required to leave 50% of their estate to the children?
Yes, there is a clause in our divorce that states that. And at the time I was, I didn't have any future plans of meeting anybody else or moving forward. And now that has happened, because I am still young, I do have a daughter, biological daughter that I have to include in that stuff. And it just doesn't work.
Okay, so Mr. Shorts, I can't go back and change a judgment of divorce.
Okay.
I mean, once the judgment of divorce is entered, it's entered and that's it.
Okay, so then I'll just leave everything in my my future wife's name, and I'll put it in a living trust to where nobody can touch it. That's fine. Because no courts can go against those.
And then you said that you are entitled to a jury trial in the issuance of a child support order, and no, you're not. You're not.
So you guys are allowed to go against Supreme Court law? Is that it? Because it's under the you can't have something without due process in a jury trial.
So no, none of that's true.
Really? Because I just beat a case and had two cases nollied and dismissed under judicial clause. Like what jurisdiction? So
child support is entered. You had due process. You had hearings. It was entered. You provided your financial information. If you're indigent and not working and you can't afford your child support, the resolution of that is to get a job. So
I am working, but the thing is you as a court do nothing for me. You as a court have failed me miserably. You have a court also told me that the Michigan Child Custody Act is a private act. It's not, because if it was a private act, it wouldn't be on your website through Lenawee County as a handbook. It wouldn't be across the state and every other county as a handbook. You as Lenawee County fail people miserably and don't protect others.
None of that really applies. So thank you. And then,
then let's take it to it. Let's push it to a Supreme Court matter, Your Honor, because you
can do that. You do have the right to appeal this to the Court of Appeals, and you have every right to do that.
I want this whole case dismissed under judicial bias because you used to be my court-appointed attorney back when I was 17. and I don't feel I have a fair trial through this court, and I
So,
want
Mr.
this.
Shorts, I represented more than 10 people a week for a period of 10 years. I may have
Yep,
represented
and
you.
I'm
I
calling,
don't
and
remember you. It wasn't
it
on this
doesn't matter.
case. And so there's
It
a
doesn't
5-year
matter.
period that has passed. So, Mr. Shorts, I'm not going to recuse myself because I represented you so many years ago on a completely different case. So no.
I feel that I'm not getting a fair trial because of it, so I'll turn it into the JTC.
This isn't a trial, this is an objection hearing. And I would grant your request if it was something I was able to grant you relief on, but these are things I can't grant you relief on.
You
No,
are
I
allowed.
have
It's
to
even
follow
in
the
my-
law.
Okay, well, so do I, because I've been seeking help because I can't afford it. So yes, I do go to other lawyers and seek help. And
Excellent.
also,
So when you can hire that attorney to do an appeal if you'd like. But so just to make a thorough record, I can't go back and change a judgment of divorce based on the reasons you said. I cannot give you a jury trial on child support. And yes, the
You have
referee
to.
does no, and the referee does have the right to issue a uniform child support order. If you wish to appeal that, feel free. So, Ms. Stone, what you're saying is your objection will be heard on the 19th of August?
We were hoping that we would be able to address all matters today because it does deal with sports that start just prior to school.
I object to that. Absolutely not. I had to wait for your guys' stuff that you ejected. It is not for that matter.
So, Ms. Stone, all right, Mr. Shorts, Ms. Stone, we'll hear it on the 19th. All right.
Thank you, Your Honor.
All right. Thank you, Mr. Shorts and Ms. Shorts, Ms. Stone.
Okay,
Thank you.
wait a minute. Why am I being dismissed? You haven't even gone through my whole entire case, so you're just going to go ahead and dismiss it and not even go through the whole process.
Those are your objections. That's all I received.
Really? Because on the back of that, there's a quorum non-judice, and you haven't even spoke about that.
A what?
Quorum non-judice. It's in the packet that you have, Your Honor, and you haven't even spoke on it.
Because it doesn't apply. Mr. Shorts, we're done for today. Thank you. Okay. Bye, Ms. Stone.
Thank you.
And let's see. All right, I'm not running behind too much, so let me bring you guys up. This is in the matter of Cedar Glen Commons versus Matthew Navarre and Brittany Goss Navarre, file number 1.
The Navarres aren't here. Want to give them a chance?
Yeah, I'm sorry. I thought they were here. All right, I'm gonna take a few minute recess.
Yeah, she did. It's something, this one's where angry, post judgment, storm power. sorry. She came out, was looking, remember here, so she went back in. Okay. I'm sorry? Would you mind if I sat up here early? Looks like we're the only one on the docket.
Pardon me?
Looks like we're the only man.
I think you were scheduled for a half hour.
Okay. Stinks listening to that guy. Not be here.
She does very well.
Wish she
She's
should.
been in here.
She should have.
Those are people that have to work on the streets.
They're doing beat cops again in Ann Arbor.
Pardon me?
They're reinstating beats on it in Ann Arbor. Foot,
Oh, foot beats.
yeah.
Yeah, it's. I was working down, so. Up there,
Yeah,
downtown.
I was actually not aware it had gone away, but come to realize, now that I'm thinking about it, I haven't seen anybody doing that. My manpower issues.
It's a site. Yeah, or ways that used to be, just like clothes,
Just like what?
just like clothes.
Yeah.
Bell bottom jeans or straight leg jeans.
Something else, oh, there's a cycle in what I do as a lawyer. It comes after a recession, certain type of work. We haven't had it since the Great Recession.
Opponent wants to come on.
Matt,
You want-
Brittany,
you
you
want-
can
Matt,
come up if you like,
Judy, you want to sit up here?
just to save that a little extra bit when she comes out.
Okay, there.
Those are my clients, but they don't have to testify, but these folks are in pro first, so they need to.
All rise.
Okay, so you can be seated. This is in the matter of Cedar Glen Commons versus Matthew Navarre and Brittany Goss Navarre, file number 21-6640 CZ. All parties are present in person. My big notes. So we are here today on plaintiff's motion for summary disposition. We have one, and then we have three of a defendant's motion for summary disposition. So I think we'll start with the plaintiff's first and then with yours. Is that all right?
Sure.
Yes, okay, so you may proceed. Counsel, can you identify yourself for the record?
Yes, Michael Carroll on behalf of the plaintiff.
Very good, thank you.
May I proceed with oral
You may.
argument? So, Your Honor, from my client's perspective, while the Navarres lived in the community, my folks had to deal with what they feel was irresponsible pet ownership by the Navarres. With regard to the pit bull that brings us together, Judge, we never denied an accommodation. We offered accommodations like fencing and leashing. We never sought an injunction before you, Judge, to have the dog removed. The case law is clear that filing suit in and of itself is not a denial. I think the court's aware we continue to try to work with them on a reasonable accommodation for that animal until it was euthanized for doing the things my folks feared. It bit Miss Gosnavar's sister. It bit a service worker. And so then discussions turned to this Mastiff or Cane Corso, Judge, and we continued to talk about leashing and things in order for them to be allowed to keep that animal as well, even though that one, there is no claim in front of the court with regard to discrimination on that animal. But even if there were, we continued to behave, I think, reasonably. You know, and the dogs stayed there the whole time before the Navarres moved out eventually, but the dogs were allowed to stay the whole time and there was no restrictions on them, Judge. There was no leashing or fencing or any kind of restriction, and the animals would get out. The hound dog would get out. The Cane Corso, we have videos of it on other neighbors' porches. You know, invisible fences are only so good. Sometimes they would lose power, a generator went down and the animals got out. You know, we never fined them for the dogs, Judge, although our position would have been we would be entitled to, but that would have just added more weight on this file. So we took the high road to never fine them for the dogs. And we went through all these mediations with Judge Rashid, and it wasn't disclosed to us at the second, and those are expensive, you know, Your Honor, in front of Judge Rashid, and it wasn't disclosed to us at the second mediation that they already had plans to euthanize the pit bull because of the bitings. And so we went through that whole day thinking we were negotiating in good faith, you know, and offering to let the pit bull stay because she had the ESA for the pit bull at the time. And we kind of thought the Mastiff was not covered by that, you know, and come to find out after, they never planned on talking turkey about the pit bull because they're planning on having it put down. So that, and of course, we didn't find out about the divorce, you know, Your Honor, until the court happened to tell us about it. And so, you know, we felt like we were engaging in an interactive process in good faith, and it wasn't so much being reciprocated. So they did bring a horse onto the property. It got out, it chased a bunch of little girls and nipped at them, but that's not really before you, Judge, but it just adds to the malaise of the experience my client had with these folks and their animals. You know, interesting to me under that case law that we've cited to you ad nauseum, Judge, is that one doesn't necessarily get his or her preference as to an accommodation. There has to be a weighing of the safety factors and things of that nature. You know, the injunctive relief that was sought in the Navarres counterclaims is moot. There's no order to be had to keep the dogs, or our injunctive relief seeking fences and whatnot is moot. And we're down to, we believe the discrimination claim should be dismissed by the court as a matter of law, and request that of you, Judge. And then on our affirmative claims, what remains would be whether there was a violation of the dog breed restrictions by the Navarres.
Okay. All right, do either of you wish to reply to that other than what you wrote? Anything else? You have to step up to the podium.
I'll reply here.
Okay, thank you.
Sure. So I'm Matt Navarre, self-representing.
today, so I don't have something really prepared necessarily, but just want to say that we lived in the community, with our neighbors. My then wife, Brittany, was living with mental health conditions. She had a lot of trauma leading up to it, and trauma throughout our marriage with losing our daughter, losing her dog. This is something that was known as far as what her mental condition was. And she was admitted to the hospital. That's where she received her ESA from. We did not know the pit bull to be dangerous at the time. That we were trying to work with our neighbors to be able to have the dog here. We did ask for reasonable accommodations in a number of different ways. We felt with the filing of the lawsuit, as Mr. Carroll mentioned, isn't necessarily saying we're not going to make accommodation, but to kind of feel that we were in the middle of trying to discuss something, and then we had this lawsuit filed against us. We were responsible, I think, to the degree that we were trying to keep the dogs enclosed on the property using an invisible fence is what we had used for that. There were also other dogs that would wander the neighborhood that were not our dogs, but we did try to be responsible to keep them on our property. There was a time that the County Corso did get off property, but when it came to let me back up, I'm sorry. So when we brought the County Corso to the property, we didn't believe that the County Corso was a restricted breed. County Corso is not listed in the bylaws. Mastiff is listed in the bylaws, but there's specific breeds that are also Mastiffs that were listed. We believe that to be more Old English Mastiff being specific to it. So we didn't think that we still don't feel that we were wrong in bringing that dog to the property. Again, we had her ESA for the pit bull. The pit bull we didn't know to be dangerous, but as council mentioned, the dog did go on to bite somebody, actually 2 people, and we were responsible dog owners. And even though it was difficult, we made the decision to put the dog down because that was the best thing for everybody. So I agree with what, they're saying is being mooted as far as where we're at with us moving out. Don't agree with the presentation of everything that way. We tried to work with our neighbors as well through that mediation process. When it comes to the divorce, our relationship is our relationship, and no divorce is final until it's final. And we're actually working with counselors, family counselors throughout that whole time, twice a week, trying to see where we were at. So you mentioned a horse issue. That was a separate lawsuit that I had filed that we have settled. So I don't know that that needs to be a part of any of this, but just trying to be supportive of my then wife, mother of my children, and we were trying to make the best decisions we could for the situation. So that's all I can say.
Okay, thank you. Okay.
I'm Brittany Bosnavar.
Thank you.
I need to say that, sorry. As Matt had just mentioned, I did struggle with mental health issues. I gave birth to my daughter and held her until she died. And then a couple months later, I held my dog until she died, and that really messed me up. I was dealing with depression prior to that, and that just added to it tremendously. I did end up asking for a reasonable accommodation November of 2019, I believe it was. I had sent Eric Elmaker an email asking for a reasonable accommodation, and he never replied back to me. And then I did try committing suicide in December of, oh, that was 2020. I'm sorry. I asked in 2020 and then tried committing suicide in December of 2020. That's when I was hospitalized and received my ESA letter. I did post something about it on Facebook, and Eric Elmaker did see that I had received a letter from my doctor about an ESA, and actually got a hold of my then husband, Matt, and was talking to him about it because Matt at the time didn't even know. So in February, we had come back to the house. We had brought the pit bull mix with us and our puppy. At the time we were staying with my family because my siblings and stuff lived out of state and we were celebrating Christmas with them. So when we came back in February, the neighbors had noticed that we had these 2 dogs. And Matt did let him know that I had the ESA letter, and Eric Elmaker said, okay, on the County Corso, and a couple days later, I was outside with my daughter, both the dogs were out, and one of the neighbors had come over and she was recording us outside. And so I got the dogs and I got the kids and we went and brought them inside the house, and I went down to the end of the driveway and I was talking with Eric Elmaker and the neighbor, and she was recording it the whole time. And, I told him, I said, I was hospitalized. I tried committing suicide. I do have an ESA letter. If you want to see it, you can. I said, Gunner is the pit bull mix. He is my ESA. The other dog is my Connie Corso. She's not on the breed restriction list. And he flat out said that she was not on the restricted list, that Connie Corsos weren't known at the time of them making the association breed restriction list. And I don't know when exactly it was actually made, but from that point up until then, there had been well over 10 years of time that they could have added if they wanted to. And he did tell me that it didn't matter if I had an ESA letter or not, that both the dogs needed to be removed from the property. I then filed a discrimination with the state of Michigan, and I never filed a lawsuit. It was just, I felt that my rights were being violated due to what was going on. They were recording us, and Eric would stand behind his garage with his phone recording us outside, and it was too much. And I was like, this isn't right. I'm not comfortable with this. This is, I asked for reasonable accommodation twice now. My husband at the time also asked for reasonable accommodations, and he said that they still needed to go. And at the time of the request for Gunner, who was the pit bull mix, there were no known behavioral issues. You can't sue somebody and saying that there is a potential that this could happen. If there were anything bad when it came to his behavior, I wouldn't have brought him to the house. I would have gotten rid of him. I had 2 young kids. It doesn't matter what breed the type of dog is. If it has behavioral issues, I'm not going to have it. So the Connie Corso did get off the property. She was wearing her collar at the time. I did not change the battery out. It happened the day before I was having spinal surgery, and my mind was elsewhere. I was freaking out about it. That was our error. After that, we bought new collars, a brand new system, put reminders in both of our phones to make sure that we stayed on top of it, making sure that the batteries were changed. She never left the property again. I now live in Heartland, and she's still on the invisible fence, and she's never left the property. Sorry, there's a couple other things I was going to mention. I did write them down. Gunner did bite someone. He nipped him in the back of his leg. And at that point in time, as soon as that happened, I started contacting rescues and shelters and stuff to see if I could rehome him. And we both were working diligently on trying to make sure that that happened. And if he was outside, we watched him, and he was always great with us, with the kids and stuff. But after that, it was like, he has to go. And unfortunately, my sister and her kids were at the house visiting. They were downstairs in the basement. The door was closed. The door was opened by our young son, and I had let the dogs out. They came into the house, and when Remy opened, that's my son's name, when he opened up the door, both the dogs went downstairs, and Gunner just attacked my sister, brought her to the hospital, and we volunteered to euthanize him because that was a behavioral issue. And it should never have gone that far. And the police did not ask us, or animal control did not ask us to euthanize him. But we made that decision because if he were to go to anybody else, that would be a huge risk. And that was really hard for me. Having to make that decision after losing my dog and my daughter a year later after getting him, it was horrible. But I did it anyways. And From there, I did apply my ESA to Sequoia, the County Corso. She, displayed ESA benefits through that year. And I really, really latched on to her during that time, and especially after losing Gunner. And she's still my ESA. She's phenomenal. I couldn't ask for a better dog to be my ESA. She's super sweet. She's next to me 24/7. She's like a leech. They don't lie when they talk about County Corsos choosing one person and being that Velcro dog. She is that 100% with me. I still struggle with mental health issues. At that time, coming home from the hospital, I wish I would have had time to just decompress and focus on working on my mental health with my therapists. But due to the issues with the association, taking videos and filing a lawsuit against us, it just was one thing adding onto another. And it was added stress on to my now ex-husband's relationship and I, financially, physically, mentally, everything. And I feel like all of that just contributed to us pushing each other away instead of receiving the actual help that I needed to get through that. There was during those couple of years that we were still there, people stopped talking to me. They wouldn't wave hi. The friendships that we had acquired while living there prior to the dogs. I mean, we would go over to each other's houses. They would come over to ours. We would all sit out and have drinks or eat or do parties and stuff. And the kids next door to us wouldn't wave hi to us, wouldn't even talk to our kids anymore. Everybody would just ignore us anytime that we were out, or record us if we walked by or drove by or had the dogs out. They were just constantly recording us. I couldn't even walk outside my house with the dogs out, feeling like I was being watched constantly. The way that everybody's behavior changed after I asked for the reasonable accommodation, it was just absolutely bogus. I mean, no one should be treated that way. It was extremely cruel and mean. I could never do that to anybody. And it was really, really, hard to deal with, especially after trying to take my own life and then having to deal with all of the extra on top of trying to heal from losing my daughter. It was like living in hell, honestly. You hope that your home can be a peaceful place and that you can retreat to, and it was never that way. After asking for the reasonable accommodation, and having that dog, it was horrible. I still stand that there was discrimination definitely made. When it came to talks of trying to come up with a reasonable accommodation, when we did do that meeting at the time, we were not talking about euthanizing Gunner. Mr. Carroll had said that we were, but we were not. We were actively looking to rehome him, not to euthanize him. That decision wasn't made until he bit my sister. Sorry. Sorry, my heart is racing. when we were speaking to them in regards to Gunner during a meeting that we had with the courts. They asked for him to always be in a dog run, that he wasn't allowed to be outside unless he was on a 6-foot leash at all times. You know, as an ESA, I have 2 small kids, you know, at the time I had 2 small kids. And as an ESA, I felt that that wasn't going to be able to suit my needs. Being outside of the home and not being able to have my ESA with me, like whether I'm playing with the kids or wanting to throw frisbee or something, I can't be able to wrangle up my children and hold my dog at the same time. Nobody else in the association ever had to have their dog on a leash. My dog prior was a pit shepherd mix, who lived there, and people would come over to our house and nobody ever had issues with her. So I wanted another dog that behavioral wise, like had that same type of temperament, was really loving and sweet. Prior to us moving in, Matt bought the house, I moved in shortly after. When he had moved into the house, he moved in with a dog. And Eric Elmaker, who was the president at the time, did tell us that, you know, this is a dog haven, you know, there's 100 acres of shared property with trails, you know, they would let their dog Mojo run off leash. And I mean, honestly, when we first moved in, both the dogs, we would take them for walks without them being on a leash, and nobody ever cared. Sam Williamson's son would run through the property with his dog, not on a leash. The McPhees brought in a lab, and that dog would run through the association and come over and visit the neighbors without a leash. There was a lot of love towards dogs in the community. And then once I brought in my ESA Gunner and brought in the Cane Corso, everything changed. People started to make sure that they kept their dogs within their property, and the McPhee's dog ran out a handful of times and they were never given any fines or any letters stating that they had, you know, violated any of the bylaws. Eric Elmaker was not the president at the time, I don't believe. I think Scott was. They had a worker over at their house, and a dog was on their property, had exited their property and come onto ours. And he was never violated. He never received anything.
So I'm gonna have to stop you for a couple minutes, only because you guys have kind of just argued your motions as well. Would you agree with that? Would you agree? Because I started out, I was just doing his motion for summary disposition, but I think now you've pretty much covered your motion as well. Do you agree with that, ma'am?
Yeah.
Okay, would you agree with that?
Yes, sir.
Right, and so I'm gonna call time on it.
Okay, sorry.
Just because I have another hearing that was set for 30 minutes too, and I'm equaling out so you get your 30 minutes, but I'm all set. So thank you, and I did read. So I guess if you could respond to their motion briefly.
Yes. Actually,
motions as well, and quickly respond on yours, and then, okay.
I actually stand corrected. Matt's testimony at that one mediation session was that he knew they were going to rehome Gunner. Brittany's correct. He did not, they had not decided to euthanize at that point, so I misspoke a moment earlier.
That's fine.
So, you know, this video behavior, that kind of went both ways. People calling police on each other, that went both ways, Judge. It may be true that Our Lady was the first to video someone though, but it's funny hearing the talk about the perception of what it was like at the community from the Navarres is kind of what I hear from my folks as well. So I guess the more salient point legally, Judge, is that when Ms. Navarre came back to the property, you know, did she have to have it be a pit bull? You know, the ESA, that was a choice, and it was a choice she made, and it didn't have to be that type of dog that had been the source of a dispute before. And I guess it just kind of comes back to what the law says on that point, Judge. You don't always get your preference of the animal. It has to be weighed with factors such as the safety of the community.
Okay. So we have 3 motions. Let's see. We have 1 motion for summary disposition that was filed by the plaintiff, and we have 3 on behalf of the defendant. The court has reviewed all of them. Plaintiff moves for summary disposition pursuant to MCR 2.116C10 based on 1, defendants violated the unambiguous pet restrictions in the bylaws by obtaining both a pit bull and the Cane Corso. 2, plaintiff did not violate the Fair Housing Act because they appropriately requested information about the need for a responsible accommodation. They have never denied a request for a reasonable accommodation. And 3, a reasonable accommodation does not necessarily require defendant be permitted her preferred choice, but simply that the accommodation is reasonable. Defendant responded that the Cane Corso is not a restricted breed under the bylaws because of the bylaws specifying the types of mastiffs that are restricted. And the general mastiff refers to the Old English Mastiff. The Cane Corso is an Italian mastiff and not specifically listed. Moreover, defendants argue that plaintiffs requested information 5 days before the filing of this lawsuit. Defendants argued that plaintiff requested additional information 5 days before the filing of this lawsuit and therefore constructively denied the request for reasonable accommodation. The motions presented by the party require a significant number of findings as the claims brought in this matter are incredibly fact specific. However, a few key issues are generally dispositive of the motions, and those are the only findings being addressed by the court at this juncture. Should the party seek clarification of additional findings they believe to be critical to these motions that are not made on the record today, the court would entertain a written motion for clarification, but will not make any additional ruling following this order at this time, given the thousands of pages of pleadings, which would need to be reviewed further for additional decision. Addressing plaintiff's motion, the first question is really whether Sequoia, the Cane Corso, is a restricted breed. If she is not a restricted breed, no reasonable accommodation would be necessary, as dogs are generally permitted in the condominium complex. Defendant's expert testified at her deposition that while a Cane Corso is a Mastiff type dog, descended from Mastiffs, the Cane Corso is distinct from a Mastiff and may have different breed standards. The bylaws restricted some Mastiff descended breeds, but not all, and also restricted Mastiffs. Accordingly, there is a genuine dispute of material fact as to whether defendant's Cane Corso is a restricted breed and whether an accommodation is even required for defendant to possess Sequoia. The remainder of the claims related to the Cane Corso are predicated on this question, and summary disposition is therefore not appropriate at this juncture pursuant to MCR 2.116C10, except the request for an injunction to remove the Cane Corso as the defendants have moved from the association. They no longer live there. Turning to the question of Gunner the pit bull, there is no genuine dispute of material fact that pit bulls are restricted breeds under the bylaws, or that Gunner was obtained without prior authorization. The subsequent request to have Gunner exempted from the restriction as an emotional support animal cannot get around the fundamental fact that he was brought to the condominium without authorization in violation of the bylaws. Insofar as plaintiff requests a declaration, it is granted. However, with respect to the remaining questions surrounding Gunner's status as an ESA and violations of the Fair Housing Act, there remains a genuine dispute of material fact as to whether Gunner posed a direct threat for which plaintiff's modification of defendant's accommodation request was appropriate. Accordingly, the remainder of plaintiff's motion is denied, except for the request for an injunction to remove the pit bull as the defendants have moved from the association. Defendant's first motion for summary or for partial summary disposition essentially makes the same argument that defendant's response to plaintiff's motion does, that summary disposition of plaintiff's complaint is appropriate because a cane corso is not a restricted breed under plaintiff's bylaws, which would also require the granting of summary disposition of count 2 of defendant's counterclaim in defendant's favor. Given the finding that there is a genuine dispute of material fact as to whether the cane corso is a restricted breed, defendant's first motion for summary disposition must also be denied pursuant to MCR 2.116C10. Defendant's second motion for summary disposition deals primarily with Gunner, the pit bull. Defendants argue in favor of summary disposition of their counterclaim that defendant's request for reasonable accommodation is effectively a waiver of the breed restriction to permit an otherwise restricted breed to reside on the premises as defendant Goss Navarre's ESA was inappropriately denied. The basis of this argument is that plaintiff had no reason to request that there be any kind of additional fencing in order for Gunner to be permitted in the condominium, because nothing about Gunner's individual behavior would have necessitated that action at that time. So, however, the commencement of litigation seeking a declaratory judgment does not constitute a constructive denial of an accommodation request, particularly when there has not been any adverse action taken against the disabled party. The defendant was permitted to keep Gunner until he was voluntarily euthanized during the pendency of this litigation. The record presented by both parties indicated that plaintiff did not deny defendant's request for accommodation, but instead essentially responded with the position that Gunner posed a direct threat and requested that a more secure fencing be installed. While there is a genuine dispute of material fact as to whether Gunner posed a direct threat which necessitated additional action, there is no dispute that defendant never responded to the request and the request was never denied. For this reason, summary disposition of defendant's second counterclaim is inappropriate at this juncture. Defendant's third motion for summary disposition essentially requests that the court find that plaintiff wrongfully denied defendant's reasonable accommodation request relating to Sequoia and seeks the complete disposition of the counterclaim and plaintiff's complaint in their favor. However, for the reasons defendant's other two motions must be denied, so too must this motion. Moreover, defendants do not allege in their countercomplaint that the accommodation request for Sequoia was ever actually denied, and instead request a declaratory judgment that either no such request was required for Sequoia or that the request was appropriately made or reasonable. Accordingly, summary disposition is inappropriate. A number of issues, just for the record, are now moot. The request for the injunction ordering defendants to remove the cane corso from the property, request for injunction ordering defendants to remove pit bull from the property, request for an order enjoining plaintiff for further seeking removal of the ESA, and request for an order requiring the association board members to attend training regarding disability housing and or discriminatory harassment. Since the defendants have since moved, those issues are kind of mute. So I will be denying all the motions for summary disposition. All right, counsel, could you do an order stating that court has denied both plaintiff and defendant's motion for summary disposition for the reasons placed on the record? Thank you. Thank you very much. All right, thank you all.
Judge, do you think I should make mention of the injunction, the granting of the injunction, so we have a record of that? Or do you think I just stick with for the reasons stated on the record and we?
That's fine, for the reasons.
You like that? Okay, I do.
Okay, all right, everybody, thank you. Do we have another court date?
I think we need to set one, Your Honor.
All right, so.
Thank you so much for doing that work, Judge.
I'm sorry?
Thank you so much for doing all that work. You just had to get through that.
I'm an Asian judicial attorney too, so she is marvelous. So I guess at this point we set a trial date.
Yeah, you want to do one more pre-trial before the trial, or?
You can do one more pre-trial. Miss Adams, can I get a pre-trial? Oh, never mind. I have some dates. Never mind. Miss Adams, I did send you a chat message though. All right, I can do September 23rd at 3:20 PM. Is that date available for you, Mr. Farrell? And that can be via Zoom if you want, or in person.
I prefer in person, Your Honor. That's a Monday, yes.
You're available?
Yes, ma'am.
Are you guys available?
Yes, Your Honor.
Okay. Miss Adams, I'm going to finish the scheduling order, and if I could get 6 copies.
Okay.
If you want to just stay there, we'll get your notice and some people there. So Miss Adams, it's ready. I just need 6 copies. All right, Mr. Harsha, are you? So here's the scheduling order. Thank you. All right, Mr. Harsha, you are appearing on behalf of the plaintiff or defendant on Linton versus Martinez.
The plaintiff, Your Honor. Good morning.
Okay, good morning. And Ms. Johnson, you're appearing on the behalf of the defendant, correct?
Correct.
Right, when we come back to the final pre-trial on that, be prepared to discuss witness list. This is a jury trial?
Yeah.
Yeah, so we'll have to do jury instructions. And I may set another settlement conference to do that, but we'll go through that day, okay? All right, thank you. All right, let me get into. All right, this is in the matter of Miranda Linton versus Jody Ray Martinez and Ricardo Antonio Martinez, file number 23-237177 NI, starting with plaintiff's counsel because I don't really have you on the pleadings. Could you state your name and your P number, please?
Good morning again, Your Honor. Bill Harsha, P number 40308.
All right, Ms. Johnson.
Wendy Johnson, 74404.
Okay, so we are here on quite a few things. We have defendant's motion to compel discovery, defendant's motion to dismiss or preclude, defendant's motion to strike. That's it. So defendant's motion to compel discovery, Ms. Johnson.
Good morning, Your Honor. There was some discussions just probably about, I'm going to say about 9:15 this morning, that we have resolved to the motions at present time. What we agreed to was that plaintiff's counsel would provide updated initial disclosures and answer discovery within 21 days. And if not, and also and that the order could
indicate that if failure to do so would result in a dismissal by the court. And then there was an agreement on the second motion for to strike Matt Zubers as a potential witness from plaintiff's witness list. And then, my understanding is that counsel had requested, and we would agree to the, if the court would permit that the computation of damages, counsel did not understand my argument on the computation of damages and wanted another week to look at it. And I suspect that that would have to be a week after he provided his discovery responses.
On the motion to strike?
On the motion dismissed to preclude evidence of the non-economic damages, it's specifically to the motion to compel the computation of damages. I think I could be mistaken, but I think the agreement was that he would have to have the damage documentation in front of him in order to appropriately respond.
Okay,
If I've misrepresented that, Mr. Harsha, please correct me.
No, Wendy, you did not. And Judge, essentially what she said is correct. This may be parsing things, but in terms of the dismissal, I would prefer language that says may be dismissed, because I don't want to, if my client is in some unknown hospital somewhere, I don't want this to be self-executing under those circumstances. But in essence, everything else is correct. I have agreed to strike Matt Zubers from the witness list. We will respond to discovery within 21 days. We will provide an updated initial disclosure within 21 days. The only issue I have is that under the court rules, I've always practiced that, with non-economic damages claims, those are not subject to easy computation, and therefore, under the court rules, we cannot be forced to respond. However, I did indicate to defense counsel that I can certainly put in there that it's worth, $1 million or $1 billion. So happy to do that.
Okay, Ms. Johnson.
Well, I guess I thought this was the argument that he wanted to put over, but if we're going to have argument on this issue this morning, the court rule does require that the computation of damages be provided as part of the initial disclosures. The information that was provided to us does not include the medical bills, and to the extent that counsel is going to stand there and indicate these are the Blackboard meds that were provided to us, that this is the number that was requested to or that was required to make my client better and recover, then I think to that extent, then I guess if he's not going to use that, not going to make that argument, then I think that's what the computation of damages provision of 2.302 requires. Is that the computation that plaintiff intends to put onto the case or put into the case is relevant, it's discoverable, and I think the court rule requires them to provide the information. And if to the extent that they want to tell us to advise of non-economic damages, then I think that there at least has to be a number put into the case. And again, I thought this was the argument that we were agreeing to put. In other words, it's difficult to make that argument without the documentation in front of counsel. But to the extent that the court is entertaining that argument this morning, then that would be our position, that without that documentation, that argument should be precluded at any eventual trial.
So Mr. Harsha, did you guys agree to put this over to another date, or?
I'm fine with that, Judge. We had agreed to stipulate that I would provide all of this information within 21 days, including an amended initial disclosures, which if they have to address specifically the categories of non-economic damages, I will do so. Certainly, if there are any economic damages, I will put those in. And if we don't have any, I'm not going to present any. And I certainly would understand the court not allowing us to do so.
Ms. Johnson?
That was my understanding, is that if he's willing to provide the information, then we are certainly willing to look at it and attempt to come up with some additional resolution. If the court wants that argument this morning, then my position has to be, we don't have any documentation, and ask that it be precluded. And so I guess that, and the only other thing that I would note is that we are at, well, let's go with it. For that reason, I have to take the position that without documentation, that it should be precluded. If the court would like to say, I'm due to the agreement of counsel with 21 days, that that we can renew this a week after that, I certainly don't have a problem with that. I am somewhat reasonable.
Mr. Harshaw?
I'm in agreement, Judge.
Okay, so what does that leave me to make a decision on today? Nothing.
I imagine what you want for lunch. I don't.
Well, I packed a PBJ, so I'm good. So, all right. Okay, so who's going to be drafting the order then from today?
I think I think it's very similar to the orders that I sent with the motion. So I will take I think I only have to change a sentence or add a sentence, and I can do that and have those submitted. I'll have them sent today. The only other issue that I have is Your Honor's preference for, I think the scheduling order is might need to be adjusted. And would you like that motion after we receive the discovery in order to know whether to be dismissed or not?
We have a pretrial scheduling order that set dates. What I will tell you is that if the two of you agree that these dates need to be adjourned out, you can do that by step. I'm not going to make you waste my time or yours coming in on a motion, so you can just say on the record you agree. What I will say, though, is that the final settlement conference, you have to get a date from my judicial assistant, and that is always in person, okay? So, yeah. So if you guys realize you need more time and you want to stick to that, that's fine. And then just get a date from my assistant. Remember that, make sure in the order that the final settlement conference has to be in person, okay?
Thank you very much, Your Honor.
Thank you.
Very much, Mr. Harsha. Appreciate it.
All right, thank you. Thank you.
Bye-bye.
All right, I do not have Mr. Noe and Mr. Rains. So let's step off the bench for a minute.
Right.
Yeah.
Can't be that.
Oh, okay.
They yell at us.
Do they really?
Jake Piper like monitors it.
Oh, really?
Yeah, so,